Hey guys, what's up? Today I'm going to do a video, and this is an education piece for all of you, because this is not taught in your civics classes. Actually, the opposite of this is taught in your civics classes, and that should be fun. To go ahead and show kind of what the truth is. And what I'm talking about today is judicial review. This is the power of the Supreme Court to go ahead and take an action of the executive branch, or really any branch of government, or a law passed by Congress, and to determine whether or not it's unconstitutional. I think we've seen this a little bit in recent days with Trump being frustrated over and over again on the travel ban, and being stopped most recently in his defunding of sanctuary cities. Here we have district court judges who are appointed, not elected, for life terms in random areas of the country, overruling the will of the voter, technically, and the power of the executive branch entirely with the stroke of a pen. You may ask where this comes from, and I do too. I mean, I know where it comes from, but I don't know why we allow it to happen. And the reason I say that is because I'm going to read to you Article 3 of the United States Constitution. And then, after I read that, I'm going to go through 4 pages of Marbury versus Madison, just the last 4 pages. There's 22 pages, so you're welcome for me not boring you with the unimportant part. But the last 4 pages of Marbury versus Madison are where the Supreme Court kind of develops this idea of judicial review. And I'm doing this video largely in response to a video by Razorfist, just released, I think, today, in which he brilliantly rants about the Supreme Court and the power of courts in general, the judicial branch being just a pile of garbage. If you're curious, I am out of Balmore. I have moved on to an Edredor 10, which is doing quite nicely for me tonight. But anyway, without further ado. Oh, go check out the Razorfist video, by the way. It's good stuff. Don't do it now. Do it later. Obviously, watch this video first. Article 3 of the United States Constitution. Brief background, if you don't know, Article 3 is the one that establishes the judiciary branch. Article 1 is the legislature, Article 2 is the executive branch, Article 3 is the judiciary. So, it's short, so bear with me here. Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. That's a lot of commas. Good job, guys. Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions as under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trials shall be held in the state where said crimes have been committed, but when not committed within any state, the trial shall be at a place or places as the Congress may by law have directed. Section 3. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless the testimony of 2 witnesses to the same overt act, or on confession in open court. The Congress shall have the power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. So that's it. And what I want you to do is think about what I just said and find in there the spot where it says that any court, much less the Supreme Court, has the power to rule something constitutional or not. I will wait. But not long, because this is a video. It's not there. It's not there at all. There is no constitutional authority of any court, much less the Supreme Court, to determine something to be constitutional or not, or to put some sort of bar on Congress or an action of the executive or an action of a state or local government to be unconstitutional. There's nothing in there that says that. So where did it come from? It came from this case in 1803, Marbury versus Madison. If there's a Supreme Court case that anyone knows other than Roe v. Wade, it's Marbury versus Madison. It's considered kind of the foundational case, and it establishes this idea of judicial review. So, brief background, Marbury versus Madison. John Adams was president. John Adams appointed a bunch of people in his last days in office to various positions. Specifically, he appointed Marbury to be a justice of the peace, and then he left office as Thomas Jefferson was elected and took over after being inaugurated. Thomas Jefferson says, wait a minute, why am I going to appoint all the idiots that this guy put in? Why am I going to put them into their offices that this guy appointed? He's my political opponent. I am opposed to him, and I have different ideas on what should be in place. So he refuses to actually have the courier deliver the letters, and the way he refuses by ordering James Madison, who is a Secretary of State. He refuses. He tells him to refuse to issue the letters of commission to Marbury and his compatriots. So Madison refuses. Marbury brings suit requesting the Supreme Court to issue a writ of mandamus, which is basically a writ compelling a government official to do what they're supposed to do. So he wants the court to tell Madison to issue the letters to give him his position. And the court spends a lot of pages going through whether or not they can do this. And I'm not going to read through that because that's really boring. But the summary of that is the court determines that Marbury does have a right to the position he was appointed, but that they're not the proper place to... they don't have proper jurisdiction to issue the writ of mandamus. So they basically punt. They punt. They say, yeah, you have a right to it, but we're not the right person to do it. So, how they get there, that's kind of the interesting part. So, Congress had passed the Judiciary Act. The Judiciary Act has been around basically from the inception of our country. It establishes how many justices are on the Supreme Court, and it establishes all of the constitutional issues around jurisdiction for the inferior courts, and what appellate jurisdiction the Supreme Court has, as determined by Article 3, right? Article 3 says that Congress can make restrictions on where appellate jurisdiction lies and all that stuff. So the Judiciary Act is how they got that, the Judiciary Act is how they got to the jurisdiction issue. The Judiciary Act establishes that the Supreme Court shall issue a writ of mandamus. And you know what? I think the best part is for me to start reading. I'm starting reading at the end of the 23rd page in one of the registers here. I don't remember which one. Doesn't matter. Who cares? So, the words of Chief Justice John Marshall. This, then, is a plain cause for a plain case for a mandamus, either to deliver the commission or a copy of it from record, and it only remains to be inquired whether it can issue from this court. So, again, you have a right to this. Mandamus is the proper way. Is this court the proper venue? spoiler alert, the court ultimately rules that no, the Supreme Court is not the proper venue. Despite them having original jurisdiction over the commission of officers, they rule that in this case they should have appellate jurisdiction, and therefore that the Judiciary Act is unconstitutional. And we're getting to that right here. The Act to establish the judicial courts of the United States authorizes the Supreme Court to issue writs of mandamus in, quote, to issue writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States, end quote. The Secretary of State, being a person holding an office under the authority of the United States, is precisely within the letter of the description. And if this court is not authorized to issue a writ of mandamus to such an officer, it must be because the law is unconstitutional. Mind you, unconstitutionality doesn't exist before that word. And therefore absolutely incapable of conferring the authority and assigning the duties which its words purport to confer and assign. And you'll have to pardon the highbrow early 1800s speech of John Marshall. He's kind of a turd. The Constitution vests the whole judicial power of the United States in one Supreme Court and in such inferior courts as Congress shall from time to time ordain and establish. This power is expressly extended to all cases arising under the laws of the United States, and consequently in some form may be exercised over the present case because the right claimed is given by a law of the United States. Okay. In the distribution of this power, it is declared that the quote, the Supreme Court shall have original jurisdiction in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. In all other cases, the Supreme Court shall have appellate jurisdiction, end quote. Which, yeah. Anyway. In the distribution of this power, it is declared... Oh, wait, I just read this. God. It has been insisted at the bar that as the original grant of jurisdiction to the Supreme Court and inferior courts is general, and the clause assigning original jurisdiction to the Supreme Court contains no negative or restrictive words, the power remains to the legislature to assign original jurisdiction to that court in other cases than those specified in the article which has been recited, provided those cases belong to the judicial power of the United States. Seems like a good argument. They go on, though. If it had been intended to leave it in the discretion of the legislature to apportion the judicial power between the supreme and inferior courts, according to the will of that body, it would certainly have been useless to have proceeded further than to have defined the judicial power and the tribunals in which it should be vested. Fallacy alert. This is what's called a false cause, or false conflict, false dilemma, false choice fallacy. They present that if one thing isn't so, then the other thing must be so. And we'll look into that in just a minute. The subsequent part of the section is mere surplusage, is entirely without meaning, if such is to be the construction. If Congress remains at liberty to give this court appellate jurisdiction, where the Constitution has declared their jurisdiction shall be original, and original jurisdiction where the Constitution has declared it shall be appellate, the distribution of jurisdiction shall be made in the Constitution is form without substance. And that's true, right? If the Constitution says one thing and Congress is free to just change it willy-nilly, then it doesn't have any power. Affirmative words are often, in their operation, negative of other objects than those affirmed. And in this case, a negative or exclusive sense must be given to them, or they have no operation at all. Is that true, though? I don't know that that's actually true. So what they're saying is that they're affirmative words, and then you can infer the negative. And if you don't infer the negative, then the affirmative words have no operation. I'm not convinced, John Marshall. Provide me an argument. But you don't, do you? Because you're the chief judge. It cannot be presumed that any clause in the Constitution is intended to be without effect. Why? Why can't it be presumed? And therefore, such a construction is inadmissible unless the words require it. Remember that there is no affirmative or negative words, either granting permission or restricting the Supreme Court to do what it's doing here. So he says that it cannot be presumed that any clause in the Constitution is intended to be without effect. and therefore such a construction, and that construction would be that the negative must be true, is inadmissible unless the words require it. But that's not really happening, is it? Because they're overriding that right now. With these words, they're going ahead and just throwing that in the garbage. If the solicitude of the Convention, respecting our peace with foreign powers, induced a provision that the Supreme Court should take original jurisdiction in cases which might be supposed to affect them, yet the clause would have proceeded no further than to provide for such cases, if no further restriction on the powers of Congress had been intended, that they should have appellate jurisdiction in all other cases, with such exceptions as Congress might make, is no restriction, unless the words be deemed exclusive of original jurisdiction. So yeah, if the court's granted original jurisdiction in one field and appellate jurisdiction in the other, we have to assume that they don't have appellate jurisdiction in the original, and they don't have original jurisdiction in the appellate. This is a tautology. Whatever. When an instrument organizing fundamentally a judicial system divides it into one supreme and so many inferior courts as the legislature may ordain or establish, then enumerates its powers and proceeds so far to distribute them as to define the jurisdiction of the Supreme Court by declaring the cases in which it shall take original jurisdiction, and that in others it shall take appellate jurisdiction, the plain import of the words seems to be that in one class of cases its jurisdiction is original and not appellate, and the other it is appellate and not original. Good job, John. If any other construction would render the clause inoperative, that is an additional reason for rejecting such other construction and for adhering to their obvious meaning. To enable this, to enable this court to issue a mandamus, it must be shewn to be an exercise of appellate jurisdiction, or to be necessary to enable them to exercise appellate jurisdiction. So he's saying that since the court doesn't have original jurisdiction in this issue, that it should have appellate jurisdiction. So he's basically saying it should go to a lower court, not to his court, to issue the writ of mandamus. But he doesn't actually say that. I don't know why. He's John Marshall. He can do what he wants. But it could be pretty well argued, and it is. It actually is argued that the court does have original jurisdiction in this case. John Marshall just disagrees. But that's fine. It is the essential criterion of appellate jurisdiction that it revises and corrects the proceedings in a cause already instituted, and does not create that cause. So again, he's really going on and on about this appellate versus original jurisdiction. Although, therefore, a mandamus may be directed to the courts, yet to issue such a writ to an officer for the delivery of a paper is in effect the same as to sustain an original action for that paper, and therefore seems not to belong to appellate but to original jurisdiction. Neither is it necessary in such a case as this to enable the courts to exercise its appellate jurisdiction. Because there wasn't a lower case, right? They went straight to the Supreme Court. Because it involved an officer of the United States appointed by the President. They thought Supreme Court should have jurisdiction. The question, whether an act repugnant to the Constitution can become the law of the land, is a question deeply interesting to the United States. That may be a true statement, John, but that's not what this case asked. This case just simply asked you to issue a writ. First, it asked if the person who was appointed has an actual right, and this is 1800, so a property right in the job they were appointed to. You said yes, and then they asked you to go ahead and issue a writ recognizing that right. They didn't ask squat about whether this is an act repugnant to the Constitution and if it can become the law of the land. That's you making that up. But, happily, not of an intricacy proportioned to its interest. It seems only necessary to recognize certain principles supposed to have been long and well established to decide it. Well, yeah, I guess. That the people have an original right to establish for their future government such principles as, in their opinion, shall most conduce to their own happiness is the basis on which the whole American fabric has been erected. Yes, people have the right of self-governance. That's the purpose of America. Welcome to it, John. The exercise of this original right is a very great exertion, nor ought it be frequently repeated. Okay, right, so we shouldn't establish a government every other week. The principles, therefore, so established are deemed fundamental, and as the authority from which they proceed is supreme and can seldom act, they are designed to be permanent. But they're not. Because in the document, there's methods for changing the document. And by the way, if they're designed to be permanent, you can't do what you're doing now, dork. This original and supreme will organizes the government and assigns to different departments their respective powers. Mind you, they didn't assign you the power of judicial review. They could have, and they decided not to. It may either stop here or establish certain limits not to be transcended by those departments. The government of the United States is of the latter description. The powers of the legislature are defined and limited. And that those limits may not be mistaken or forgotten, the Constitution is written. So the Constitution is written to limit the power of the legislature. Okay. And the judiciary and the presumably the executive. To what purpose are powers limited, and to what purpose is that limitation committed to writing if these limits may at any time be passed by those intended to be restrained? Yeah, that's a good question. That's why we have an executive branch with the power of the veto, right? That presumably is the purpose of the executive veto. The distinction between a government with limited and unlimited powers is abolished. Is it, though? If those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proportion too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act. Yeah, except there are checks on this. There are checks built in. The executive veto is a check on legislative overreach. And the courts are a check on legislative overreach as well, because the Constitution is the supreme law of the land, as stated in the Constitution, which is a little circular, but okay. So if it's the supreme law of the land, then it supersedes any subsequent laws. But they don't grant you the power to determine those laws to be invalid. They simply grant supremacy to the Constitution. Which doesn't mean that a law is necessarily invalid. It just means that when you apply the facts to the case, you may find supremacy of the Constitution overrides the existing general law. Ugh. Oh my God. So this judicial review thing isn't in the Constitution. You're making it up. And that's kind of annoying. Let's see. Where was I? Here we go. Between these alternatives, there is no middle ground. This is tantamount to a false choice fallacy, right? The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts. No, those are not the only two things. I just laid out that there is a middle ground in which the Constitution exists, ordinary legislative acts exist, and the facts of the case may weigh in favor of a certain person to rule that the Constitution has supremacy over the others. We use supremacy in federal versus state questions all the time. And the supremacy of the federal government does not invalidate the laws of the state. So we have precedent for this in the Supreme Court. The supremacy of federal law is primary. The federal law is supreme to state laws where they directly contravene. The question the courts have to answer is, do they directly contravene each other? If they do, then federal law wins. But if they don't, state law applies. And in this case, if a federal law and a general, or if a constitutional statement and a general law conflict directly, then yes, the Constitution should win every time. But it doesn't mean that the federal law is invalid. That should be a fact-specific question. Sorry. If the former part of if the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. You made that up. That's not actually the necessary logical conclusion of the preceding statement. If the latter part be true, then written constitutions are absurd attempts. No, this is again a different false choice on the part of the people to limit a power in its own nature illimitable. It's not illimitable. It simply means that there's a fact-specific question that must be asked. You're absolving the court of its duty to determine things on their merits. Certainly, all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation. Certainly? Are you sure of that? And consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. I don't think that that's the theory of every such government. I think we have examples in history that contravene your assertion, John. This theory is essentially attached to a written constitution and is consequently to be considered by this court as one of the fundamental principles of our society. It is not therefore to be lost sight of in the further consideration of this subject. If an act of the legislature repugnant to the Constitution is void, but you haven't established that it is void, you argumentatively and conclusively determined it to be so, but it doesn't have to be. Does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? No. No. Again, a false choice. You don't have to give it effect. You just have to weigh out whether it is superior or inferior or in direct conflict with a constitutional statement. You state it's repugnant to the Constitution, but that is a fact-specific question, not a broad legal conclusion. Or in other words, though it be not law, does it constitute a rule as operative as if it was a law? This would be to overthrow in fact what was established in theory, and would seem at first view an absurdity too gross to be insisted on. It shall, however, receive a more attentive consideration. I don't think you actually give it a more attentive consideration. You give it a dismissive consideration. It is emphatically the province and duty of the judicial department to say what the law is. Is it? Then why isn't that a constitutional power? Why isn't that a constitutionally mandated authority of the judiciary in Article 3? Maybe because it's not emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. Must they? Why? If two laws conflict with each other, the courts must decide on the operation of each. Yes, that does not render the other law invalid. It determines that the court must determine which one applies, not which one exists. So if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably with the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. No, the court must not. Well, I mean, I guess. But the supreme law of the land is the Constitution. The Constitution controls. So if they're in conflict, if both apply specifically, yeah, it becomes a fact-specific question then. This is a very essence of judicial duty. I agree with you here, John, but the problem is your conclusion from this is that one of them can be determined to be completely invalid, whereas the alternative would be that it is invalid in this case, not invalid on its face. If then the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution, and not such ordinary act, must govern the case which they both apply. Yeah, if they both apply to a specific case. Those who controvert the principle that the Constitution is to be considered in court as a paramount law are reduced to the necessity of maintaining that courts must close their eyes to the Constitution and see only the law. Not true. Again, false choice, false dilemma. There is a middle ground in which you simply demand that the court determine each specific case on a fact-by-fact basis applies to the Constitution or to the general law. They're not always going to be in conflict. This doctrine would subvert the very foundation of all written constitutions. No, it actually wouldn't. Not at all. It would declare that an act which, according to the principles and theory of our government, is entirely void, is yet, in practice, completely obligatory. No. No. That's the role of the court, is to take a case and determine whether a law applies. We do this in every other aspect of law. Only here are you determining that a law should be entirely invalid based on this particular set of facts. It would declare that if the legislature shall do what is expressly forbidden, such act, notwithstanding the express prohibition, is in reality effectual. No, it would not do that. And by the way, there's already a check on that. It's the executive veto. It's also the two houses of Congress having to agree, and then an executive veto, and then two houses having to override an executive veto if they so believe this to be the case, in which instance they're darn close to a constitutional amendment anyway. It would be giving to the legislature a practical and real omnipotence, with the same breath with which professes to restrict their powers within narrow limits. It is prescribing limits and declaring that those limits may be passed as pleasure. No, it's not. You're making that up. That it thus reduces to nothing what we have deemed the greatest improvement on political institutions, a written constitution, would of itself be sufficient in America, where written constitutions have been viewed with so much reverence, for rejecting the construction. I don't think so, because you're rejecting the Constitution right now. You're doing an extra judicial or an extra constitutional exercise of power, probably the biggest power grab in the history of the United States by anybody. But the peculiar expressions of the Constitution of the United States furnish additional arguments in favor of its rejection. I don't think so. The judicial power of the United States is extended to all cases arising under the Constitution. Yes. Yes, it is. That means that you have power over this case, which you're refusing to have power in, by the way. Could it be the intention of those who gave this power to say that, in using it, the Constitution should not be looked into? No, that's a false statement. That a case arising under the Constitution should be decided without examining the instrument under which it arises. Rhetorical statements don't do you well, John. They're not helping here. This is too extravagant to be maintained. Yes, get indignant on us, please. In some cases, then, the Constitution must be looked into by the judges. And if they can open it at all, what part are they forbidden to read or to obey? You're doing a straw man here. No one says that the judges are forbidden to read or obey the Constitution. Again, fact specific to the case at hand. There are many other parts of the Constitution which serve to illustrate this subject. Here we get into a great argument by Chief Justice John Marshall. Bear with me, we got about a page left. The Constitution declares that no bill of attainder or ex post facto law shall be passed. Okay. If, however, such a bill should be passed, and a person should be prosecuted under it, must the court condemn to death those victims whom the Constitution endeavors to preserve? I don't know, John. Why don't we ask the future in which they do go ahead and apply bill of attainders and ex post facto laws when it's convenient for the court? Partly because of you stating what's constitutional and what's not. No person, says the Constitution, shall be convicted of treason unless the testimony of two witnesses to the same overt act or on confession in open court. Here the language of the Constitution is addressed especially to the courts. It prescribes directly for them a rule of evidence not to be departed from. Not to be departed from. Yet the court does depart from it in the future, in World War II. If the legislature should change that rule and declare one witness or a confession out of court sufficient for conviction, must the constitutional principle yield to legislative act? Well, it must not, except when the judiciary oversteps its constitutional authority and takes power to say that it can rule these laws constitutional. Sorry. Whew. From these, and many other selections which might be made, it is apparent that the framers of the Constitution contemplated that instrument as a rule for the government of courts as well as of the legislature. Yes, that's why Article 3 exists, and that's why this power is not granted in Article 3. Why otherwise does it direct the judges to take an oath to support it? This oath certainly applies in an especial manner to their conduct in their official character. How immoral to impose it on them if they were to be used as instruments, and the knowing instruments, for violating that which they swear to support. Again, this is a straw man. The oath of office, too, imposed by the legislature, is completely demonstrative of the legislative opinion on this subject. It is in these words, quote, "I do solemnly swear that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge all the duties incumbent upon me as according to the best of my abilities and understanding, agreeably to the Constitution," which is italicized for emphasis, "and laws of the United States." John, you're undermining your own argument with the oath because you're saying that the laws that are in conflict with the Constitution or inferior to the Constitution don't apply. But in your oath, which you're using as evidence to state that the Constitution is supreme, it pays homage to those laws. Why does a judge swear to discharge his duties agreeably to the Constitution of the United States if that Constitution forms no rule for his government, if it is closed upon him and cannot be inspected by him? No one has made this argument. But what you have done is given a judge the power to open the Constitution beyond the text and to state that the judge has power beyond what is granted to him. If such be the real state of things, this is worse than solemn mockery. How is it worse? Because you're stating, in this case, that the legislature and the executive cannot exceed their constitutionally mandated authority while exceeding the judiciary's mandated authority. Like, you're doing what you're saying is repugnant to the Constitution right now. To prescribe or to take this oath becomes equally a crime. Then you're guilty of a crime, John. It is also not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally. Well, yes, the Constitution is a supreme law. It is superior to the general laws. That's not an argument that we've made, that anyone's made. But those only which shall be made in pursuance of the Constitution have that rank. Why? You made that up. That's not in the Constitution. That they must be made in pursuance of the Constitution. We can actually have laws that are not made in pursuance. We have tons of laws, by the way, not made in pursuance of the Constitution. The argument that these laws are made in pursuance of the Constitution is tangential and ridiculous if we're being charitable. But we go ahead and give those laws authority until they go ahead and disagree with the Constitution directly on a fact-specific matter. That's how it should be, but you eliminated that in 1803, you jerk. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void. That's not in the Constitution, you liar. You made that up. And that courts, as well as other departments, are bound by that instrument. Yes, courts are bound by the instrument which you are superseding right now. The rule must be discharged. You made that up. And that's great. That's the end. That's the end of Marbury versus Madison. But I'm going to rant a little bit about it here. Because this ruling has set the stage for 200 years of judicial review. Judicial review is where courts look at a case and they look at a law that is supposedly opposed to the Constitution in the context of this case. And then they determine that law to be either constitutional or not. And that ruling has sweeping implications because our courts adhere to a rule called stare decisis, which means that it's the idea of precedent, right? So if the court has ruled on an issue, if the similar issue comes up, it is bound by the previous ruling. Now the court, being the arbiters of what the law is, has found ways to throw out stare decisis all over the place, right? They overturn decisions all the time when it's convenient for the court to do so. And that's an okay thing. But this is all a product of the construction of John Marshall in Marbury versus Madison. Too many M's in 1803. Way too many M's. This is all his construction. Like, he constructed the system that made laws voidable by the court, which was never in the Constitution. I really don't know if we have any evidence that this was intended by the framers, but this is where we ended up. Razorfist. Razorfist has asked a good question. Razorfist has asked, why are we bound by the rules of these courts? Like, what is our power to recall judges? And there is an impeachment power over judges. There is no recall power over judges. Congress, right, like anything can be done by a constitutional mandate, or by a constitutional amendment. Sorry, not mandate. Constitutional amendment can do anything. We could technically make a constitutional amendment to ban, like, Christy Flowers from ever achieving citizenship in the United States. And maybe we should do that. We could do that. The constitutional amendment process is broad, or not broad. It's narrow. Sorry. You know, Edrador's hitting me. Speaking of which, I need a little more. But constitutional amendments are narrow. They're difficult to obtain, and they carry the force of changing the actual text of the Constitution. We can do whatever we want. It's very difficult to accomplish this. And that's how the Constitution is supposed to be changed. Razorfist asks the question, how do we recall judges? Well, a constitutional amendment would do so. That seems a little bit burdensome. The real question is, why are we bound by judicial decisions? Why is the judiciary ranked third by the founders, by the way? If you notice, first is the legislature, second is the executive, and third is the judiciary. And I don't think that's an accident. The judiciary have made themselves, through Marbury versus Madison, to be a primary power of the Constitution. But the framers of the Constitution envisioned them to be a tertiary power. And there's good reason for this. The courts in England were freaking terrible. They're terrible. They're not just. And so the power of the courts to hold matters of life and death in their hands, in the hands of one person. Like, let's break this down logically. A legislative body has several people and does not have sole authority to end the life, liberty, or property of a person. Why do you think it's first in the Constitution for the framers, who just came from a system where the executive authority, being a king or a monarch of some sort, has the power to end the life, liberty, and property of any person at their whimsy? Okay, that's the first part of monarchies that these guys don't like. The next part is that the monarchy establishes the courts who enforces the will of the monarchy, where again, you have a powder-wigged moron sitting on the bench with the authority of life and death over a specific person. This is offensive to the founders in every way. The reason they put the judiciary as third in line, is that they did not want a system where a judiciary or an executive had the authority to end the life of a citizen unless at first being ordered to do so by an act of Congress, right? Congress has the power to implement everything. Punishments, all of this stuff is implemented by Congress through law, approved by the executive, and then enforced sort of by the judiciary. I guess ruled on by the judiciary. The executive goes back to the executive for enforcement. But the idea that a judge has so much power is offensive to the founding of this country, just in the same way that the idea that a king has so much power is offensive to the notions of our founding documents. So the Razorfist, sorry, I'm jumping all over here. Razorfist asks the question, why are we bound by the authority of justices? And I will tell you exactly why. It's because we have given them the authority. The public, the executive, the legislature have just gone ahead with judicial review for years. But it's not always the case. And in every case where judicial review has been thoroughly and effectively challenged, the judiciary loses. The first instance of this is Andrew Jackson. Briefly, there was a pastor ministering to Native American tribes on native land that was sovereign, set apart from the United States. This pastor was arrested by the native tribe and held in their whatever jail system they had. And Andrew Jackson did not stand for that. Andrew Jackson, by the way, not a friend of native tribes at all. In a lot of ways, a terrible human being. And by the way, that jerkhole screwed up the whole Senate. So we're not going to give Andrew Jackson a lot of play here. But the one thing he did do, which is important, I mean, he did a lot of important things, but one thing he did that was especially important in this context is he stood up to the Supreme Court. The Supreme Court, basically, the United States wanted to go in and get this this preacher out of the Native American tribe, but this would require them invading a foreign nation, basically, a sovereign nation. The Supreme Court said no. That was not in the power of Andrew Jackson to do this. And Andrew Jackson famously said, "The Chief Justice has made his decision. Now let's see him enforce it." The president has an army. Congress has the purse strings. The judiciary branch has neither. They don't have an army. They don't have the purse strings. At most, they have, what, like a couple guards for each justice from the Secret Service? And those guards have a couple guns. The president has literally a giant standing army that they could call upon at any time. Or a militia. They could call them to arrest the judiciary if the president determined they were treasonous. That would be a mess. That'd be interesting, right? Anyway, Andrew Jackson wins. Like, the Supreme Court can't do anything to Andrew Jackson. They can't do anything to the president. The next case, we have FDR, right? During the time of the New Deal, his New Deal measures are being struck down left and right by the Supreme Court. And FDR goes to the court and he says, "Hey, idiots, knock it off. My plan needs to go in, or you're enemies of the country. And if you're enemies of the country, as a court, what I'm going to do is I'm going to appoint 10 justices. I'm going to appoint one more than all of you. And they're all going to be favorable to me. And they're all going to do what I want. And you'll have to sit there and have every one of your stupid decisions overturned." And the court miraculously started finding New Deal provisions to be constitutional when prior to that they had been unconstitutional. The executive branch wins over the judiciary when the executive wants to. When the will of the people are behind the executive, they win. Because the will of the people overrides the judiciary branch, especially in matters where the judiciary branch has overstepped their constitutional authority, like this one. So, to answer Razorfist's question, what obligation do we have to be bound by the judiciary branch? We don't have any. We've done it as a social agreement in our country. We've given the judicial branch the authority for years and years and years, decades really, maybe centuries. We've given them, outside of the couple isolated incidents, right? We've given them this authority. We've deferred to their judgment, and that's fine. But that doesn't mean that that judgment actually holds any weight beyond what we give it. It's a fiat currency. And that's important to note, because we right now have a president who has positioned himself as a strongman. And I think Trump is setting himself up to go against the judiciary, and he'll probably win. Because the judiciary has no authority outside of what's in the Constitution. And when Trump wins because of the overzealous acts of district court judges, we're going to see some real changes as to how the judiciary is respected and treated, and maybe very damaging changes. I don't have faith in Trump to execute this with finesse by any stretch. Finesse does not seem to be his strong point. But the idea that the judicial branch overrules everything is offensive to the very notion of its drafting. It's the shortest section of the three branches of government. The least amount of power is conferred to them. The only power the judiciary actually has was taken in Marbury versus Madison. This is the source of all of it. It is extra constitutional, and it persists only because we allow it to. And that's important to remember, because as we have district court judges in San Francisco or Honolulu overruling the elected office of president, where an entire country has gotten together and through the process laid out in the Constitution agreed that this is the guy that should run it, for better or worse, whether you like him or not. This is the way the founders laid out how we elect a president. This guy was elected. We've determined by public assertion that this guy is the right guy for the job. So to have an unelected appointee of a political opponent in another state, in one city, overrule that, it's only a matter of time before those overrulings start offending the public that elected a president to change things. And when that happens, when the perfect mix happens, the judiciary loses every time because they don't have an army and they don't have the will of the people and they don't have elected officials. They have people appointed for life. And at the end of the day, you take the person you choose over the person thrust upon you every time, because you can always change the person who you choose, in theory at least. You can change them when they start going the other way. I hope you guys found this case informative. Marbury versus Madison is often cited as one of the most important cases in constitutional history. I would agree with that. I would say it is wrongly decided. It is a massive power grab. You don't hear that in your 8th grade civics class or whatever grade you guys took it. I took it in 8th grade, and it was terrible. I assume if you got a public education like I did, it was similarly garbage. Maybe you had a good teacher. Good luck. But in any case, this isn't the way it's taught in civics class, and that's probably for a specific reason. But this isn't the way it is. This is extra constitutional power taken in probably the biggest power grab in United States history by the judiciary. And I want to point this out because it's there, and some good things have come from it. I'm not saying that all judicial review has been bad, but some bad things have come from it too, right? Korematsu versus whoever. Doesn't matter. Korematsu. Go look it up. Korematsu is where we intern Japanese people based on them being Japanese during World War II. The court upheld this as constitutionally valid. Like, this isn't constitutionally valid, for one thing. It's a horrific overreach. But the idea that now, in another case, in the future, in which we determine during a time of war to categorize people by race and put them in internment camps and to take their property and give it to people of another race, like, that's good law. And technically the court is bound by that by stare decisis, by the idea of precedent. That's a terrible aspect of judicial review that we get as a part of this. Yes, judicial review has made certain things illegal. Razorfist points to Roe versus Wade as being an atrocity, not because in his opinion that abortion is wrong. Razorfist believes that the government has no say over fallopian tubes or a uterus of a woman. I might have some disagreements there. It doesn't really matter. He says there's no say, and that Roe versus Wade is actually damaging to the pro-choice cause because it gives, by being a complete fabrication by the court, similar to Marbury versus Madison in a lot of ways, by creating this right that doesn't exist, the court has then given the alternative argument a target, a giant target with which to fire all of their ammunition at repeatedly throughout history. Roe versus Wade was decided in, 1972, 1973, and we still argue about it today. It's not the controlling standard, but it's the idea. The idea that the government must allow abortion is offensive to a lot of people. And the idea that the government won't protect life is the particularly offensive part. But it doesn't matter what side of Roe versus Wade you're on. It's a polarizing topic for both sides. And this is because of judicial review, because of judicial overreach, because the court in Marbury versus Madison stepped beyond the Constitution to take power that they weren't granted, to state that other branches couldn't take power that they weren't granted. It's the most hypocritical nonsense I've ever heard. And it's a foundational case. It's never taught in this way. I hope you guys have found this entertaining. I hope you guys have found this informative and educational. And if not, tell me all about it in the comments, and I would be happy to ignore them or take them as I see fit. Just kidding. I'm open to criticism. I will talk to you guys later. Have a good night, and thanks for watching.